We're good.
Good morning.
All right.
We are on the record.
All right. I want to call the meeting of the July 2018 Tennessee Real Estate Appraiser Commission to order. Roxanne, would you like to call the roll, please?
Absolutely. Thank you, and good morning. Today is Monday, July 16, 2018. We posted proper notice on the Commission's website on July the 11th. I will start by calling roll. Ms. Rosemary Johnson is not here with us today. Mr. Randall Thomas?
Here.
Mr. Mark Gregory Johnstone is also not here. Dr. Warren McCara?
Here.
Mr. Rex Garrison?
Here.
Mr. Jim Atwood?
Present.
Mr. Jason Bennett?
Here.
We have a quorum. You may proceed.
Thank you very much. We're going to alter our agenda a little bit, but I would like for you all to look over and approve the minutes from the 2018, April 16, 2018 meeting. Have you all had a chance to look at those? Do I hear a motion?
So moved.
Second?
Second.
I have a motion second to approve the minutes from the April 2018 commission meeting. All those in favor say aye.
Aye.
Any opposed? Motion carries. Do you want to hear the legal report at this time, altering the agenda just a little bit? We want to go ahead and hear the legal report.
If we could do the interviews
Okay.
first, if that's okay, that way some of the individuals that may need to go back to work can
okay.
head on out, and then we'll do the legal. Thank you.
Okay, sure thing.
And your interview page is on page 19. We've added a couple, which I really appreciate everybody being patient with that, so I'll add those two at the end. We can start with Randy Thomas. You had Miss Ann Stone, and it's on page 19.
Yeah, hang on just a second. I'm rolling over to 19.
I believe I handed everyone a paper version as well, if that
Yes, you
helps.
did. I think I handed mine back to you.
No worries.
Okay. Yes, I had Miss Ann Stone. She is well-versed in what she's doing and has done, even though she's going from trainee to certified residential. She's done quite a bit of commercial work, and I would recommend that she be approved to go to certified residential. You want to vote on these all together or one at a time?
Totally up to you.
Okay. What would be the
We can
pleasure of the
begin.
commission? Vote on these all together or one at a time? Okay, we're going to vote on all together. It's good enough for me. Moving down, I also had a 500-hour discussion with a young lady, Sarah Redding, who is also already has way over her number of hours. She's already got 1,500 hours, but she's worked less than a year. So all she was here for was a 500-hour review. And then I had Patrick Gallagher, and Patrick is going from trainee to certified residential. However, when his log was reviewed, all of the residential reports that were asked of him were 2015, 2016. I told him that I certainly thought he was well-versed in what he had learned and what he could do, but I was going to hold off approving him until he sent us a 2018, and I selected one, and he said he'd be glad to send it in. And I would recommend to you, Roxana, or whoever, let's always ask for one of the reports in that calendar year, because the first thing I asked him was, what have you been doing since 16? And he said, working. And I said, well, how come I don't have an 18? And he said, I'm sending you what they asked for. So I would recommend his approval based upon this 2018 report coming in. So that's my three.
And on the hours for Ms. Reading, the recommendation was also for a yes.
Yeah.
Thank you.
Yeah, everything's good. Okay, Rex?
This morning I met with Timothy Goodwin. He's going from a trainee to a certified residential. He has not passed the exam. Reviewed the reports, met with him, and I would approve his experience. The second one, Jason DeBusk, he is going from trainee to certified general. He has passed the exam. Met with him, reviewed his reports, and I also approve his experience. Make that recommendation.
Okay, very good. Mr. Atwood?
Yes. I met with Denise Smallwood, This says she did not pass the exam. She told me that she did.
I'll look into that to make sure that she did.
Regardless, I am not prepared to recommend her at this time. She's going to submit some additional work that we'll be working on between now and the next. My other two are not on here. Ian McKenzie, I do recommend him for certified residential. And then the one I just...
Clarence Martin is the one we added at the last minute.
Yes, Clarence Martin, I will also recommend him
Okay.
For his upgrade from licensed to certified residential.
We've accounted for everyone, and the reports that are pending, Mr. Atwood, will come to me, and then we'll get them to you, and that would be on Ms. Smallwood.
Correct.
Now, we would need a motion based on the recommendations.
You've heard the recommendations from the interviewers.
He didn't show up.
What about, I just have a question. Colton Wood?
He didn't show up.
He did not show up.
Oh, okay, no
Yeah, so
problem.
we'll follow up with him
Okay.
and see what he'd like to do.
Okay. Okay, you've heard the recommendation from the reviewers. Do I hear a motion? Motion's been made to approve the experienced interview hours. Do I hear a second?
Second.
Motion been made and second. Any further discussion? All those in favor say aye.
Aye.
All those opposed? Motion carries for interview experience.
Perfect. Now we can skip to the legal report, I think. Was that the
Okay.
decision?
Any of you in the audience that have been here for your experience interviews, you're welcome to stay, but you do not have to, but you're welcome to. Okay, moving to the legal report. Sarah?
Robin.
Robin?
You're starting on page 22 on your iPads.
The very first case we
were,
have,
but they changed it back. Okay.
the very first matter we have this morning is 2018-013-751. Do you wish me to read into the summary into the record, or do you want to just review it and ask for?
These,
Just review.
yeah, these were sent to each one of us, correct? Because I read a bunch of them yesterday.
they were.
Yeah. Okay. No, you don't have to read these, just the
Okay.
numbers. And we'll take just a minute and go over these. All right, Robin, would you care to read your recommendation?
Happy to. My recommendation for this particular matter was a letter of warning concerning reasoning regarding adjustments as required by SR 2-2A8.
All right, fellow commissioners, you've heard the recommendation from legal counsel. Any motions?
I was wondering, would a sales comparison course be advisable in this particular case?
You can do that. A sales comparison course would be then a part of a consent order, which is different than a letter of warning.
Exactly.
And so then there has to be an agreement on the part of the respondent to take that course.
Disciplinary history of this individual, there was a consent order already out that they agreed to in 2016. We don't know the detail.
It was a use PEP course.
Am I on the right place?
Oh, no, there's only, number one only had a 2008 consent order.
I'm going to go to page 22.
Get me on the right thing.
You're on page.
Thank you. Now, 2008. There we go. All right, let me reevaluate since I got to reread.
Okay, well, Mr. Atwood's reading that. Any discussion from other commissioners? Go ahead, Rex.
I was going to make a motion.
Go ahead, sure.
We accept council's recommendation.
Okay. Motion's been made to accept council's recommendation.
Second.
Motion's been made and second. Now, Mr. Mr. Atwood, you wish to have any discussion?
Well, only to say that not supporting adjustments is, to me, a very serious situation, especially for someone who's already had a complaint. But that was 10 years ago. We'll give them benefit of the doubt on that.
I was kind of feeling the same way. The only thing it said, the reviewer found that the appraisal overall was done in an appropriate manner, supporting credible value. So I see what you're saying, but let's hope in 10 years we've improved.
And I think the, I don't know, credibility or validity of the complaint seems a little ridiculous. So I don't have anything else.
The only reason why I mentioned the sales comparison report is in the reviewer's conclusions. It said that the sales comparison, or in the sales comparison approach, there was not adequate reasoning provided for the adjustments.
I consider that serious
Yeah.
myself. As long as the letter is going to state that they need to upgrade their sales comparison adjustments, it will state that specifically.
It'll say exactly that the reviewer found there was not adequate reasoning provided, and that they should take caution and make sure that all future reports contain that. Yes, that's what the letter will say.
All right. Any further discussion? Motion's been made and second to accept council's recommendation on legal number 1. All those in favor say aye.
Aye.
Any opposed? Recommendation carries. Number 2.
Yes, number 2. This was presented in April 2018. It's 2017-072-451. And as a result of last month's or April's meeting, you all voted for a consent order to require a 7-hour comparison course and a 7-hour cost course, and respondent then further responded through an attorney, which you can review in the document.
Everybody had a chance to read it? Robin, would you read your new recommendation?
Yeah, this was approved for a consent order with continuing education. It cannot be predicted on a hearing result, but it is likely there will be conflicting experts offering conflicting conclusions. That's not a reason to make a change, but as this commission has determined that for future matters, a conditioned dismissal is now planned for certain matters where the recommendation is for a continuing education course, this may be appropriate in this matter resolve the pending matter. The problem is that what you all have in place, I understand, is something that you don't see beforehand, and now you've seen this. I will tell you that there isn't. This is no. Y'all haven't seen me litigate. I don't know if you have or not. I'm really aggressive, so there's no reason not to litigate. But I just want you to know when it comes down to conflicting experts, that's always going to be a problem in any kind of litigation. This might then be appropriate for a strong letter of warning, outlining the issues that were found, or you can keep with your original consent order, which was for only continuing education. But she's not going to sign that, or he's not going to sign that. I can't remember what they are.
I guess my question on that would be, so the solution to getting out of this is to have a strongly worded response from an attorney. And then we say, okay, well.
Okay. Any further discussion?
I really don't see any difference from what's given to us in this individual's supposed violation, and the first one that we just did, and all we did was a letter of warning on the first one. This seems to be the same thing, but the difference in this case is this is the appraiser's first complaint. So I would make a motion that we change our decision to a letter of warning that would, and it has nothing to do with whether it goes to hearing or not. I think in the interest of just being fair, that we change this to a letter of warning.
Matthews pointed out, we can also put in a letter that the commission does suggest that this person take a class. We can put that in there. Can't guarantee it'll happen, but I can put that in there.
On that conditional requirement before, wasn't it said that we would specify what classes they would have to take?
So yeah, we were going to hit on that later. We've actually done our first conditional dismissal, and it's been signed and executed. And it went to an expert. I conferred with the expert on what class we thought was necessary for that individual who had never been disciplined before. And then we specifically told them what class to take. And then it also counts towards their continuing education. So far we're having great success.
I think that would be more applicable
This
than a
probably would-
letter of warning, because now we're getting somewhere. They're taking a class and getting better.
Yes, but this respondent's not going to sign.
But that doesn't require a consent order, does it? A conditional?
So but it's a citation. It's not discipline. It's continuing education.
Right.
So, I mean, I guess technically Robin could write one up and present it to them as this will not be discipline, but here's the course they want you to take.
Yes, I can do that. I can do that, but I can tell you that it's not going to be agreed on. I mean, that's, again, no reason not to do it, but I'm just giving you.
Has it been mentioned that it wouldn't go on their record then?
No, it has not been mentioned, but
Okay.
but from the review I have, that the party strongly feels that there weren't violations, very strongly feels that, and that they have an expert online ready to say there weren't any. That's where we are.
Go ahead.
How do you dispute the fact that there is information incorrect on the comparables?
Well, there is a dispute about that they weren't incorrect. I say one person says one thing and one person says another. I'm happy to do the conditional, I'm just telling you the
I just
good,
feel
bad,
like
and the
it's
ugly.
different from the first case, where the first one was that there was not support in the report for the adjustments. That doesn't mean the support wasn't there, it just wasn't notated. In this case, we're saying specifically that there's data in the comparables that was incorrect.
I understand, as and I said, and this person strongly disagrees with this particular reviewer, and, reviewers are like everybody else.
I guess my other concern is that the respondent prepared the report with the skill, competence of licenses in the county and surrounding areas. I don't want him comparing himself to the people in the county and surrounding areas. I want him comparing himself to what USPAP requires.
Only concern is to go back to what Jason said originally, so if you get an attorney, then what we had to say to begin with doesn't mean much.
Well, no, I don't think that's it at all. It's just that when an attorney, let me just rephrase this. I am an attorney. My opinion
forgive
is, yeah, I'm sorry. Please forgive me. I don't even play one on television. But my opinion is, frankly, for almost every type of program I work with, if an attorney prepares the response in the first place, sometimes things are presented differently, that can be presented to you differently from the legal point of view. That's not what happened here. The attorney didn't get involved until after the fact. Doesn't mean anything, but it does mean that the viewpoint is such that they are looking at it from what can be proven and what can't be proven if we have a hearing on it. Again, not a necessary reason to make any kind of different decision. It's just that, frankly, probably this would have been presented entirely differently if we'd had the kinds of response I had in that from the attorney in the first place. Doesn't mean you would have come to a different conclusion, but it does mean that the presentation would have been somewhat different.
What was the course that was recommended?
Courses that were recommended were
2 7-hour courses.
A sales comparison and a cost.
right.
Okay.
So from a bigger picture, hearing everything you've said, if we do the conditional agreement, we assign the same classes, and if they take the classes, what I'm looking at is how can we get to where we wanted to begin with, and that's getting them educated under those classes. But if we go this route, is that something that can be presented in a hearing, saying we offered that?
No.
can't be?
No, typically when you do have a trial of any sort, you're not really allowed to put in the proposals beforehand. It prejudices the entire matter. So no, that would not be presented.
Okay.
And you're removing the fine, is that right?
I'm sorry?
You're removing the fine that was in the original recommendation?
There wasn't one.
There wasn't one?
Yeah,
Well, they're in the recommendation.
yeah,
We
with
removed the
classes.
fine, yeah.
Okay.
So, I don't know, and let me just bring this up, if I do the conditional agreement and send it out, an attorney might advise that person, it's cheaper for you to do this than to fight it. But they might say, if you want to fight it, I had a big trial this last week with Trek that I lost, and I don't usually lose, but it was a very close area of law that wasn't exactly right, and it was a very small civil penalty that was offered to the person, but they were adamant about going forward. So that can happen. What will happen is that if they don't agree to your conditional, then we'll be in the same spot we are now, and I'll bring it back again, and then you can make a determination one way or the other to go forward and say, that's it, we're going forward with the hearing.
Are we out of line to ask an individual to come in and explain themselves? I mean, without
The problem with that is, if you have an individual come in and explain themselves, and it isn't resolved, then where is it going to be heard? Then you'll have to agree to have the matter heard before an ALJ alone, because you all will not be able to
Okay,
make an
I
unbiased
understand that,
decision.
okay, yeah, all right. Any further discussion?
With the one, but-
We've heard the new recommendation from legal. Do I hear any motions?
Well, I already made one, but it didn't get seconded.
Oh, I'm sorry. Would you care to make it again? I don't remember you
I'll
making
make
it.
a motion that we simply give a letter of warning that includes our concern about inappropriate adjustments.
All right, you heard the motion. Do we have a second?
Second.
Okay, we have a motion and a second to change the new recommendation to follow the guidelines of what Mr. Atwood has commented. Any discussion on that?
My concern is the fact that one of the properties that were used as a comparable, so there's some disputing, but they're missing a 2-bedroom with a second kitchen apartment. That's not a matter of an adjustment that is completely leaving out details of, I guess it is an adjustment, but you missed a big part of a comparable that would have been negative adjustment. It's going to have an impact on value, and that's at the top of that page.
Any further discussion?
What I'm wondering is the requirement that they take the sales comparison course doesn't help alleviate your concern about that?
Well, we're not saying that. We're saying that by doing this, we're just going to send them a letter to say,
My motion doesn't include requiring a course.
It does?
It does not.
Does not.
Just warns them that they need to get their sales comparison.
All right, we have a motion and a second on the floor. Any further discussion? All right, we're going to vote on a motion. Motion is to send a letter of warning with some instructions in it. All those in favor say aye.
Aye.
All those opposed say no.
No.
Okay, motion fails. Does someone want to go back and make a motion?
I move we accept council's recommendation on the conditional classes.
I'll second that.
All right, motion's been made and second to accept council's new recommendation. Any further discussion on that? Hearing none, all those in favor of the new recommendation say aye.
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 All those opposed say no. New recommendation passes. Number 3, please.
2017-076-501, again, this was in the April meeting. At the conclusion of that meeting, this commission voted to have this complaint reviewed by another expert and to be represented. You asked specifically that the new review include a report these following items: scope assignment in comparison of the scope to the engagement letter and the instructions from the client, if the scope was communicated to the respondent, how the appraiser did or did not meet the scope, how was the sewer relate to the highest and best use, did it have an impact of value, and if the appraisal was in compliance with TDOT. This matter was reviewed by another expert who found several errors and missing information, and I addressed each of those particular concerns, which are outlined below. My original recommendation was a $2,000 civil penalty for violations of the standard rules of 11B, 12, 12H, 14, 21, and 22. My recommendation remains the same, but I am asking that you all discuss this particular matter as you had asked for additional review on it.
You all had a chance to read this?
So, someone remind me why we wanted to know if the report was in compliance with TDOT. I don't see anything. We requested that.
Yeah, I don't think we asked for that. It was noted in the original review that there was a proposed take, and it wasn't mentioned in the report.
It was that was one of the requests.
Yeah, I think Gary
That was a
asked. I think
specific request.
Mr. Johnstone asked for that, yes. I think I remember that. All right, you've heard council's recommendation. We have any discussion on this? Anyone wish to make a motion?
Well, discussion-wise,
Okay.
even after the second review, I'm still a little off in what exactly was in this report. So after it being reviewed twice, I think there's definitely a communication issue in that report. And so I have a recommendation, and what I was going to throw out is I would forego the civil penalty and require not a 7-hour USPAP, but a 15-hour USPAP and a minimum of 14-hour report writing, because it just sounds like there's a communication issue with this report.
Is that discussion or is that a motion?
That's a motion now.
Okay. Motion is for a 15-hour USPAP and a 14-hour course writing?
Yes.
Okay.
A second.
Okay, motion's been made and seconded that this recommendation go to a 15-hour USPAP course and a 14-hour course writing course. Any discussion on that? Okay, we're going to vote on that motion. All those in favor say aye.
Aye.
Any opposed? The new motion carries. Number 4.
Thank you, gentlemen. That concludes my portion of the report.
Okay,
Thank you again.
thank you, Rob.
We're going to skip to number 7 and let Ms. Smith take care of hers.
Number 7.
Number 7
Yes, sir.
and 8.
Yes, sir.
Mr. Chairman, I will need to recuse myself from both of those cases, 7 and 8.
Start on page 35.
35?
Yes.
Why do I have page 12? No, it says 12 at the bottom.
It's just tap it with your thumb.
bottom, then that'll show you.
See?
It's technology.
Oh, okay,
That-
okay.
that's how-
Okay.
Those are different.
Are we all ready for number 7?
Yes.
Okay.
Can I just take a time out a minute? I have a question for legal counsel. With Mr. Atwood recusing himself, can we do this?
Yes, you're fine because you have a quorum, a present quorum, so you can continue going.
No, I think we had to have a quorum with the majority being appraisers.
You do have a quorum with the majority being appraisers.
Tell me where, please.
Well, just because he's recusing himself from one vote doesn't get rid of quorum.
Proceed.
Number 7 is 2017051051, and this was originally presented at the November 2017 meeting. I'm going to skip down to new information. Would you like me to read all of that for you?
No, I would not. I remember
Okay.
this. Go ahead.
Okay. do you want me to paraphrase or just make my new recommendation?
Make your recommendation, because I remember this.
Okay. So my new recommendation is to close this matter with private discipline in the form of a letter of warning, citing the violations that are listed in the summary, with a notice that if more violations are committed, there will be public discipline if the commission agrees with this added wording to the letter of warning, and also including wording that that council will need to be provided with proof that the final portion of the advanced legal writing report course has been passed within the time frame they have given respondent, and respondent plans on registering for that by the end of the month.
That's a new recommendation, correct?
Yes.
Just because this, let me ask you a question, just because this went to one of our commissioners and that commissioner sat down with these people, are they abreast of this new recommendation at this point in time?
The respondent?
Yeah.
Yes.
Okay. Okay. All right, you've heard council's new recommendation. Any discussion?
I just want to go on record as commending Mr. Atwood, Commissioner Atwood, for his efforts with this particular person.
I would agree. In serving on the commission 2 years, I think this is about the second time we've done this. I think both situations had a great outcome, and the whole point is to get someone along to the point of knowing what they need to be doing, and I think that was done.
I was wondering if we could have language in here that encourages this appraiser to stay in touch with Commissioner Atwood. Is that?
I'm agreeable to that. I can add that to the, we
Okay.
can revise the recommendation to include
I
word.
guess we better ask Commissioner Atwood if he's willing to do that.
I'll step outside and ask him if that's okay, unless you have maybe any more questions or comments.
We don't have, just ask him about that.
Oh, okay.
Okay. All right. You've heard the council's new recommendation. Do I hear a motion?
So moved.
Second.
Motion's been made and seconded to accept council's new recommendation. Any further discussion? All those in favor say aye.
Aye.
All those opposed say no. Motion carries. Thank you. Number 8.
Thank you. Number 8 is 2017-076901, and this complaint was filed against the same respondent as number 7 around the same time. And before all of this took place, the steps the respondent took, the informal conference with Commissioner Atwood. Do you want me to read anything other than my
No.
recommendation? Okay.
No.
So my recommendation for this, and I kind of like to revise it a little bit. I would like to just include this complaint number in the letter of warning that we're going to send with number 7, because I feel the respondent, all of the steps she's taken and the coaching going through February of next year will cover anything that was an issue in this complaint above and beyond.
All right.
So my recommendation would be to close this matter with a letter of warning, the same letter of warning as number 7.
All righty.
Will there be any language in here that if this isn't cleared up or this appraiser doesn't demonstrate improvement, that the license will be revoked?
The language I was recommending to include in the letter of warning would be language that if any further violations are found to be committed when I present it to the commission, that public discipline or whatever the commission finds necessary, if more severe, will be implemented to let the respondent know on the front end that that's what's going to happen next. There's nothing else. No more.
We've already had 3 strikes, and this is...
Right. I wouldn't want to narrow it to revocation, just letting them know that
Okay.
public discipline up to revocation.
Okay. Thank you.
But that would be up to you at the time.
Number 8 will be included with the discussion or with the letter from number 7. Do I hear a motion to accept council's recommendation?
So moved.
Take a vote on the recommendation. All those in favor say aye.
Aye.
Any opposed, say no. Motion carries. Thank you very much.
Thank you.
Sarah? You get Mr. Yeah. Go to where, 4?
Yes, you're going to go back to number 4. That is on page 28, I believe, yes, at the bottom, page 28. We're back to 4.
All right, Sarah, number
I'll
4.
give him a minute because he's
Oh.
ending a phone call.
Oh, okay.
I'll go ahead and read it into the record. Number 4 is 2018-022-761. And just so you all, just to give you a little, if you've read this or not, this primarily was on the issue of an incorrect lot size that was listed on the appraisal.
We're on number 4, on Sarah Matthews' report, number 4, page 28.
All right, sir.
You all know, I did make a little note on here. I spoke directly to the expert, and he said, yes, the lot size was incorrect, but that the value of the lot was still okay. So that is why I did a recommendation for a letter of instruction, and I think just kind of laid that out there to say, let's be a little more careful in the future. And I don't think it was intentional that he did the wrong lot size.
Do we know when the information was changed?
That I do not know of, because I have some dates where they showed where the lot size, as of, I think it was December of last year, the lot size was still the old lot size, but then in May, or recently this year, it's shown the new lot size. So I don't have that, I don't believe I have that date 100% set in stone.
Had a chance to read number 4, and Sarah's already gave her council's recommendation, which is a letter of instruction. Any motions on this?
I have a motion to dismiss.
Okay. Motion's been made to dismiss number 4.
Second.
Motion's been seconded to dismiss number 4. Any discussions on the new recommendation to dismiss? Voting on a new recommendation to dismiss. All those in favor say aye.
Aye.
Any opposed? Motion carries to dismiss. Number 5.
2018-032-761. And my recommendation on this one was to close with no action, so that would be dismissal.
Okay. Since it's voted to dismiss, you all have had a chance to read number 5. Any discussion?
I make a motion to dismiss.
Okay.
Second.
Motion's been made to accept council's recommendation. Second. Any further discussion? All those in favor of the recommendation say aye.
Aye.
Any opposed? Recommendation carries. Number 6.
Number 6 is 2018-030481. Just so you know, this one alleges unprofessional conduct, and it's a little confusing, but the complainant was not hired to actually review the appraisal, but the lender forwarded the appraisal to that individual, I guess, to ask some questions, and so that person then filed a complaint with us. The lender forwarded the appraisal, because I don't know if they thought it was incorrect, to an outside appraiser, which is the complainant in this. So they really had nothing to do with the whole transaction in general.
But the complainant is also an appraiser.
Yes.
Okay.
On this one, my recommendation was for 14 hours of coursework, and I made a note that I thought maybe sales comparison would be the best.
Also thought a report writing and highest and best use might be,
We could divide that up. We could
Possibilities.
do 7 hours in sales comparison, 7 hours in something else, or we'll let
my
the
colleagues here.
experts tell us what to
Defer to
do.
defer to the experts here on that.
I don't know who this reviewer was, but use them again. This is a proper review report.
This individual does a great job, and I appreciate his or her help all the time.
My only question on the thing is 14 hours enough?
Well, and
Suggesting 3 courses.
so maybe if we did 7 of sales comparison, 7 report writing, and 7 highest and best use.
Well, I mean, it's obvious we need to do something as far as highest and best use. I mean, there's nothing that they put in obviously filled in a space and went on to the next. So, I mean, that's, of the 14 highest and best use, I think should be at least one of them. And whether we need to raise it to 21 is up to the commission. So let's open it for some, well, we've heard a recommendation from council. Do I hear a motion? Okay, no motion. Let's open it for discussion, further discussion, because apparently there needs to be some.
Well, as I said, I suggest that we have 3 courses: sales comparison, report writing, highest and best use. I'll leave it up to you to decide how many.
Is that a motion?
Yes, I move that.
Okay, we have a motion for sales comparison, highest and best use, and course rating.
7 hours each.
Okay,
The problem is, I don't know of any of those that are just 7-hour. They're at least 14-hour courses, as far as I know.
Wouldn't have to list the number of courses. We meant to put it on your iPads again this time, but just due to different issues and shortages of staff, we didn't add it. So you can list the name of the course or the topic that you want, and then they'll have to find with a minimum of 7 hours.
Right,
And then they
right.
would have to find one that's higher.
That may be the best route to say. They need to take the highest and best use sales comparison report writing at a minimum of 7 hours apiece.
minimum of 7 hours, okay.
Yeah, and I can look it up and,
Okay.
put a minimum of 21 hours, 7 hours apiece, kind of write that out in the consent order and make sure that I communicate with this individual on what we are asking of them.
I'll amend my motion then to do it the way you suggest, Sarah.
Minimum of 7 hours. All right, motion's been made to have a sales comparison course, a highest and best use course, and a contract writing course, minimum of 7 hours. Do I hear a second?
Second.
Motion been made and second. Any further discussion? Voting on the new recommendation. All those in favor say aye.
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 Any opposed? All right, the motion carries, Sarah. Those 3 courses, minimum of 7 hours.
Perfect.
All right, thank you. Does that complete legal?
That completes the legal report. I know the only thing under legal is Roxana had the proposed rules. Contract writing. I wrote report writing, though.
Okay.
I got it.
Sorry about that.
What we are looking at right now is the rulemaking hearing will be at the next meeting, which will be October 15th. We do expect to have a lot of people at this meeting for the report for the rulemaking hearing. We also have a possibility that we may have a hearing scheduled for that meeting. So Roxanne and I have talked, it may last longer than one day. So everybody may need to prepare for that. Just knowing Roxanne and I have done a rulemaking hearing for other programs, and it wasn't contentious, and it went for a long time. There's a lot of public comment. I'm sure there'll be individuals here that want to comment on that. So just to give everybody a heads up.
Will lunch be provided?
Pajamas will be.
I would say for the rulemaking hearing that we will probably do something where we can order lunch and bring it in, because we will have a court reporter, so we'll want that to kind of continue as smoothly as possible. I know Roxanne and I have kind of talked about possibly the first day would be the hearing. Since it is an ALJ scheduled, they're on a specific schedule, so they already have our dates. Once we finish that hearing, we would go on and do meeting business and possibly doing the rulemaking hearing on day 2.
Okay.
When will we know for sure on the hearing?
Huh?
When will
I talked to Dennis, who you all may know. He was going to file the notice of hearing and charges, so he was planning on doing that last week or this week.
So with cases, as you all know, they could settle the day before, but you'll know at least a week in advance to make your hotel reservations for the 2 days in case we think that you need to. And
I was planning to be out of
the day before or the second day.
vacation that week, and I was going to make arrangements to be here the one day, but now we're eating into 2 days.
Yeah.
I mean, we hate to not schedule it for 2 days because if we don't, we could be here until 10 o'clock at night, 11. I mean, we would just go until we finished, and I know that would put you still in a bind. So we
I'll
just
adjust accordingly.
We just kind of wanted to,
Yeah.
but we know with the rulemaking hearing, it does have to be noticed 52 days ahead of time. So right now, we're on schedule for that to be at the October, unless for any reason we had any hiccups with that rulemaking, which I don't foresee. We're trying not to push anything until January because that is when the ASC will be here. So we don't want to overload that meeting as well with them here.
Okay. All right. Moving along on the agenda, we're going to alter the agenda a little bit. Mr. Nobles is sitting here patiently waiting to address us. We have a request from a licensee. Mr. Nobles, you want to come to the microphone and address the commission? Sure.
As I was talking to Glenn, I sent you guys a letter in regards to wanting permission.
It is. Speak into the microphone.
It is, okay. And wanting to take the exam with your permission again. On 2 of the times I was in the exam, not making excuses. I literally, after like an hour and 30, 45 minutes, I just had to finish the exam. My father was in the emergency room. Then later my father died, and you don't know me from Adam, but I just didn't have, emotionally, physically, just, I didn't have the heart to pass. I mean, I failed, and I'm responsible for saying that. I'm embarrassed saying that. The truth of the matter, I apologize. And it's, I've got a game plan now. I'm trying to, take the next 3 to 4 months in finishing my last 2 appraisal reports to submit and to be evaluated, and then possibly take the exam. But that being said, I was residing here in Nashville 7 months last year, driving 5.5, 6 hours daily to take care of my father and just to see him through. And I just didn't, there again, to reiterate, not making excuses. I wasn't prepared.
So your reason to appear in front of us is just to get permission to take the test again?
Yes, sir.
Okay. Is that within our realm, Sarah?
I will tell you under Rule 1255-01-.04, Section 4, the Commission may grant exceptions to the requirements set forth in this paragraph, which is the examination paragraph. I did talk to Roxanne about this. It's completely within your authority to grant him the ability to take the exam again. What we would suggest is that you put a time frame on it. So he needs to take the exam within the next year, within the next 6 months, whatever you all feel necessary from today.
Okay, thank you very much. I guess I would...
You have his letter, I'm sorry, on page 44 of your iPads, if you want to take a minute to review everything that he put before you as well.
No problem. But I would open the floor to any of the commissioners that wish to address Mr. Nobles in any form or fashion. Anybody have any questions for him?
I have 2 questions. Aren't they allowed to retake the exam anyway? We're talking about the state exam.
Yes.
Just because you don't fail the first time, don't they have the right to take it more than once?
I believe 4 times.
He cannot take it any more than 4 times within a year. I was actually unsure what your request was. Has it been over a year?
It's been
over a year since you granted that.
Okay.
How many times have you taken the exam?
3 times.
So this would be your 4th.
But it's
been over a year.
It's been over a year.
Explain that again, then I don't.
So the rule says each applicant shall complete all application and examination
I got
requirements
you.
within 1 year. So he's just over that time frame, which is why I suggested possibly adding a time frame on this.
So, but your request is to not pay the exam fee again or something? What is your request?
You have to pay the exam fee with PSI. PSI, PSI has to have the permission from you all that I can take the exam again.
You're not asking for a waiver on the fee, though?
No,
or-
sir.
No. He's just asking the permission to take it. Okay.
Yes.
Any further discussion?
One other quick question,
Sure.
and I'll shut up. Is there no provision in the state statute for emergency situations?
I wasn't aware of any medical or emergency. I couldn't find anything. So we found this one that says you all have that authority to grant him any exceptions that you see.
Okay. You've all read the statement that he sent in, heard his comment. Have you any further comments? Do I hear a motion in this matter?
I just make the motion, we give him permission to take the exam.
Okay, motion been made. Do I hear a second?
Second.
Motion been made and second. Further discussion?
Do we need to set a time frame?
Yeah, Sarah
Like
suggested that.
6 months,
Yes.
Within the next 12 months.
12 months?
From today's date.
Do you have, while we're still in discussion, do you have a time frame in mind?
I feel like 6 months is adequate.
Okay. Okay.
Whatever you
So
you
we've
decide.
had a motion here of 12 months, so
That's more
that
than-
works comfortable to
yes,
you?
yes, sir.
Okay. All right, motion's been made and second that we grant this gentleman permission to take the test again within the next 12 months. Any further discussion? Voting on the matter. All those in favor say aye.
Aye.
Any opposed? Motion carries. Get with Sarah.
Yeah, and then just so you know, if we'll talk to you after, but if you do take it within the next 12 months and you don't pass, then you would process over again the application and
Okay, so just, do I need to stand here?
Congratulations, huh?
Thank you. We had another person, but they're not here, right?
That's correct. No, yeah,
Okay.
everything's been taken care of.
Okay, so we want to hear the director's report.
Let's go back up to the education report.
Oh, I'm sorry.
And we skipped it, and then we'll be back on track, and we're
Okay.
going to be done at noon.
Sorry, Doc.
is the hope, yeah.
Okay, the Education Committee, which is me,
And it is on page 20 for you to review.
It's on page what?
20?
we're in a split decision, though, okay? No, there were 18 course applications, all of which were continuing education. 17 of the courses were traditional classroom, and 1 was online. There was 1 individual course proposal for continuing education, and there were 2 course instructor approval applications. The Education Committee recommends approval of all 18 course applications, the 1 individual course proposal, and the 2 course instructor applications.
All right, you've heard recommendation from the Education Committee, from the entire Education Committee. Any discussion on those? Do I hear a motion?
Motion to approve all.
Okay. Second?
Second.
Okay.
Well, I can't
Wait.
second
No,
it.
no. All right, motion's been made and second. Actually comes from committee, probably doesn't need a second. All those in favor of education report, say aye.
Aye.
All those opposed, say no. All right, motion carries. I just have a quick question about education.
I don't know how to clear a room.
Do we ever re-evaluate instructors? Or once you approved, you're approved?
No. Every application includes information about the instructor's qualifications. There may be a change, for instance, so there could be a legal issue, and that, it needs to be noted if there is a violation, because you have to indicate if there's been any violations that they've been accountable for, and question, they have to indicate what, they need to explain that.
Sure,
Okay?
sure.
And I'll usually bring that to the attention of the committee. Fortunately, there weren't any in this particular batch of applications, but yes, there have been, and I brought that to the attention of the commission, and generally.
Okay, just checking. All right, Roxanna,
Thank you.
director's report.
Okay, so we are now on the reviewers of the scope of work, and I will turn it over to Commissioner Atwood in a minute. Now, you do have a revised paper version of his review, so even though page 42 on your iPads shows what we had as of Friday, this morning we received a new one, so if you could, I'll address you to use the paper to review and we can discuss. And then I did also just email you a form that Commissioner Jason Bennett sent for your review as well that he uses. And the goal is, of course, to come up with a good final product that everybody's comfortable with so that we can present and use this at least with our review appraisers.
I will tell you, since you just got Jason's, Roxana and I discussed before the meeting that this may be something that we want to come up with a committee, maybe a committee of 3. Jason and Mr. Atwood are both local, so we could do something where the two of them could come in and we could call somebody and we would notice it just like a regular meeting. That way we could get this, driven down to exactly what we want. So if that's something that you all would be interested in, we can discuss creating that committee.
Okay. Kind of a subcommittee.
Yeah, it would be
Okay.
a subcommittee that could meet and kind of,
Sure.
come up with a final product that could be presented to the commission.
Sure, okay.
I have a question on the actual review itself. I know we get your summarized version. Is it possible if we come up with our own format that we actually can see the entire thing as opposed to your summary?
If it's designed to remove the names and information.
I would want to run that by my chief counsels just to check, just so you understand right now, like if a respondent comes in and does a records request, they don't get that review because it's attorney work product. I don't know that if we had something that is actually presented to you all, it would make it then discoverable, and so anyone could see that. And that's not something we've done in the past. So I would want to run that by them just to see if there's any other programs that perhaps do that. It is something we could do on a go forward. What you see on mine is pretty much exactly what the reviewer is writing. I just take out some of the words or the sentences that I don't think that you all need to see. I kind of get down to the nitty gritty. But we could look at that on a go forward.
So for now, in front of you, you only have what we asked Commissioner Atwood to prepare to share, and we can discuss the 5 points. Then when you get home, you'll see the email forwarded with the form that Commissioner Bennett has, and be able to review and make a decision, and we can try to have individuals come together and finalize something for the October meeting, that kind of thing. We can communicate through email back and forth. We just received, of course, as you all know, we're short on reviewers, so we're hoping to start a few more here soon.
Are you at liberty to tell us the number of reviewers we have?
So what we try to do is our goal is to have 3 in each grand region.
That's good enough for me. Thank you.
What we're slacking at currently
Yeah.
is Middle Tennessee.
Okay.
So luckily what we have done in order to get these reviewed, I know it doesn't matter to you all, but we have metrics. So once a complaint comes in, we only have so much time to turn it around. Otherwise, we get dinged on it. And so what I've done on the ones that are in middle that I don't have a reviewer on, I've sent to the other reviewers and asked them to look at it and tell me if they're competent to review that. If they tell me no, then it's simply right now getting put in a pile that we don't have an expert on until we get an expert.
I am going to say something. At the last meeting, I'm guilty of being pretty harsh on the reviewers, and I want to apologize for that because they're an important element to this process, and I didn't. It was more frustration just reading through the reports and not feeling things were being communicated properly, and I just want to apologize to them. We do, at least I appreciate everything that they do.
Well, and I mean, maybe that's where we can go with this. Robin and Erica both presented today. Next month, it will be just me. They were finishing up what they had in the pool, so they're all mine from here on out. And I typically get my reports to Roxana a couple weeks ahead of time, and they could come to you all earlier. And if you did have specific ones that you said, we want to see this portion of the review, then we could pull it out and try to get that piece for you, redact it and everything that we need to do. Maybe that would help a little bit because, like you said, these experts are a great resource for Roxana and I. This first conditional dismissal, the respondent was actually very excited that it wasn't going to be discipline and that we were asking them to take instructed courses, and they were more than willing to take that course. And I kind of had an idea of the courses from the expert review that I wanted, but I was able to confer with the expert and say, here are the courses that I'm thinking. Which ones do you think would best suit this individual? And so they are a great resource for both myself and Roxana. So
And as you all know, because I did have to reach out to everyone on a desperate couple cases that we're going to run over, we really are short. And so hopefully here soon we'll have a few more contracts, but we're still short. It's an issue, whether it's the RFP itself or individuals just being very busy and not wanting to go down this path. In the next year or two, we're going to have to see if this is still working, or we're going to have to look at a different way to get them reviewed.
Yeah, that's what happens when one of your Middle Tennessee reviewers gets appointed to the board and you lose a reviewer.
Not to feel, don't feel guilty.
Okay. Let's hear from Mr. Atwood.
Okay.
Just as a reminder, and Commissioner Garrison's already alluded to our being hard last meeting on reviewers, I'm not sure I apologize for my role in that. One of those, just to give an example, one of those came up again today where the individual said that just because they did an update, a reviewer did an update on an appraisal, that was a new assignment. That is so incorrect. That it discredited everything else, in my opinion, that he said. And that he may have meant it differently, but the way he said it was not correct. So if we're going to have USPAP compliant reviews, we need to have reviewers who understand USPAP, and so. I don't know who you might be able to get or obtain as additional reviewers, but there needs to be in their resume some idea of their understanding of USPAP, because that's crucial for our understanding. So I prepared this one page that's been handed out. It is completely from a residential appraiser's perspective, so therefore the commissioners on the panel here that are general appraisers might want to add additional thoughts. But as a reviewer for the state for the last 5 years, some of these very same violations occur in almost every residential report. It's amazing. They just commit the same mistakes over and over, and I've identified those in the bullet points at the bottom. Hopefully each of you have had opportunity to read. This is just kind of a draft of a scope of work, my ideas, but certainly would appreciate any modifications that the commission would like to make or answer any questions.
One question.
Yes.
Can you explain number 1?
Yeah, develop an opinion as to the merits of the complaint. What I mean by that is there are so many frivolous complaints filed against appraisers. I mean, they're just absurdly ridiculous. And maybe the reviewer does not have the ability to make that judgment call. For example, the complainant is biased. You didn't appraise my property high enough. Well, that may be a legitimate complaint, or it may just be a property owner who's mad. Another example that comes to my attention frequently is that realtors are turning appraisers in because in their minds the appraisal's too low. Well, the realtors are not getting their commissions. I'm not saying there's not merit to the case. I'm just saying that somebody gets mad at an appraiser for whatever reason, and they seek to get them back. Well, I think somebody needs to make a judgment on that, whether the complaint is even merited or not.
Okay. No, that's really what I wanted to know. Because a lot of times, I will say it from a home inspector, reviewer, land surveyor, reviewer perspective, those boards, I make a lot of that judgment call and say, I'm not sending this to an expert. For land surveyors, this is simply a boundary dispute, and that's not something that would need to be reviewed by an expert. Unfortunately, every appraiser complaint that comes in says the value of this property was too low. And we always send them off to an expert. That's just our protocol here, because I can't look at, the appraisal and say, oh yeah, that's a USPAP, da, da, da. And whereas to me it may look like, oh, this looks frivolous, and then they tend to come back with, 4 or 5 use PAP citations that I would have never caught. And so I don't have a problem with asking the expert, give me a sentence at the beginning if you think this is completely just an upset individual that's filing this complaint, because I don't have a problem putting that in my summary to you all, saying, the expert thought that this complaint
And
is
if I could
frivolous.
add to that, we see that on a level that is very, very large, where you have agents who are threatening appraisers if it doesn't come back the way that they think it should come back, and telling them, I'm going to file a complaint against the board because of, X, Y, and Z. When, unfortunately, majority of appraisals, when they get looked at by a reviewer, are going to have some kind of error.
Right. And so I always try to, 9 times out of 10, that respondent will make a note in there. The complainant told me if I didn't do X, Y, and Z, they were going to file a complaint against me. And so I feel those are important comments to let you all know, because even if there were, maybe a couple use PAP violations that to me, they look serious, but to you all, you may be like, oh, that's something that, even the best appraiser would miss. It's always good to know that the complainant was making that kind of comment. So
I guess one of my concerns is when you have a homeowner or a property owner that says the appraiser used the wrong comparables. My first comment to that is, what qualifications does the homeowner have? And if that appraiser has a license, who are we to sit here and to rebut what a former commission has done by issuing that person a license, thinking that they're reasonably qualified? It runs all over me when it says, homeowner said you used the wrong comparables. I just want to say, could you care to give me your educational background in the appraisal business? And the truth of the matter is, going back to what Mr. Atwood said, if a property had appraised and they got their loan or they got their sale, they don't care if you use the wrong comparables or not. They're just, as long as that deal goes through. And the same thing would be with realtors. Realtors don't care what comparables you use. If I'm selling it for $100,000, you appraise it for $100,000, that's wonderful.
that may be where Mr. Bennett and Mr. Atwood were talking about the real estate agents. A lot of our complaints that we get aren't coming from real estate agents, but that doesn't mean that the real estate agent isn't telling that homeowner the wrong comparables were used. A lot of times an agent may not want to file a complaint against an appraiser because then the appraiser knows who filed it. So it could just be someone in their ear telling them.
There's a subtlety in number 1 that I'd like to be sure I distinguish and everybody gets it. We have the complaint, okay, but then we ask the reviewer or the expert to review the entire report, not just based upon the complaint, but upon USPAP compliance. So there's 2 components. There's a complaint, and then there's USPAP compliance. And this is what you were referring to a moment ago. And so for me, point number 1 in the scope of work for the review appraiser is you're still going to do this over here. You're still going to do the USPAP compliant thing. But does the complaint have any validity to it at all, or is it frivolous? What's your opinion on the complaint itself? That just gives us as a commission somebody's view that, the complaint is they underappraised it for $500 or $5,000 or whatever it is. And then we have an expert that says there's no validity to that. That helps us a little bit. But that doesn't negate the fact that maybe USPAP violations still occurred that we still have to deal with. Sure. I just think a statement of some kind referring to the complaint by the reviewer would be helpful. That's all number 1 is.
Okay.
Questions?
If you don't mind, Roxanne, Sarah, I'd like to get together with you and talk about this subcommittee and see what we can do after we've read what Mr. Bennett has supplied us with. That way we can maybe combine the 2 and probably, just from my point of view, go to somebody like Rex who does a lot of commercial and see what else might want to be tossed in there that those of us that are basically residential might be overlooking. That way we get the full scope of what we're looking for, but we can do that at a later time.
I think that's perfect.
Okay.
That's absolutely, so we'll stay on top of that.
And I think the reviewers would probably
Yeah.
appreciate having a little more guidance if they can have some, a list of questions. Does it do X, Y, and Z? Otherwise, they may just be reviewing it how they've always reviewed it, and because you wouldn't believe one reviewer is totally different from another. So when I look at two different reviews,
We do believe it.
you get very used to one, and you get a couple from them, and you get a completely different one, and I'm like, wait, where are the violations noted at? So
Yeah, fantastic. So we'll make sure to follow up on that and get everybody an updated version. Sounds good?
Are there other things in your director's report?
Yes, the evaluation piece, if you will turn to page 45, this is an email from former Commissioner Eric Collinsworth, and it is page 45, I'm just confirming. And this is regarding, as you know, the evaluation questions. We're treating them kind of as a guidance to our appraisers that have asked, can we do this? How do we do this? They're on our website already and available to the public. He posed a good question, so we've got the entire email for you to review. And Sarah and I really didn't have the answer. We figure you all need to kind of read it and see if it is something that we need to address, add to it, take away. And then I've just got two other items plus your 2019 dates. So we're getting to a good point at the meeting.
Anybody have any discussion on Mr. Collinsworth's?
I do. He and I have discussed this repeatedly since we worked together. I guess the concern is the confusion potentially that arises from putting a certification on an evaluation. Specifically as it relates, one for USPAP, that if you're acting as an appraiser, then USPAP should apply. But beyond that, with complaints, the other side of the equation that you guys don't get to see is the examinations for FDIC or OCC, the confusion that it's going to create when one of these isn't what they would agree with as far as comps or value. We have dealt with the FDIC on several occasions where they didn't agree with a specific evaluation for a client. Now, the client's required to have a copy of the resume in file, but I feel like if you're putting your certification on the evaluation, it creates more confusion than it does solves problems. We were discussing it would be the same if you're an agent and an appraiser, and when you're signing a contract for a real estate transaction, you put your certification on there. We just feel like that it doesn't bring anything additional to the evaluations other than creating confusion and the potential for lawsuit saying, well, this person's an appraiser, they were acting as an appraiser, they put their certification on there indicating that they were an appraiser, but they didn't comply with USPAP.
I've got copies of the Attorney General's interpretation, and I don't know if y'all, there, I think they're highlighted, yep. Sarah, want one? Here's my standpoint, and one, it would have been good, this was brought up twice as far as the Q&As before, and it would have been better to discuss that at those opportunities before everything became official. But this thing I've read, reread, I've hashed, I've set it aside, and I've got several points to that. One is evaluations are starting to be used more and more. We've had the commercial real estate threshold increase from 250 to 500, so it's going to create more opportunities for financial clients to use evaluations. Historically, because appraisers have either felt they can't do them, or two, and this outside of Tennessee, they can't do them per state law. There have been companies that have been developed to perform evaluations. Most of these evaluations by these other companies are done outside the area, outside of the state of Tennessee. And reading this and rereading this and thinking about it, discussing it with chief appraisers from across the country and whatnot, who better to perform an evaluation than an appraiser, for one? Because they are educated, they are experienced, they are qualified to perform this product. And that's exactly what it is. It is a product. It is a valuation product. The Attorney General back in 2010 made this interpretation. This is what we have. I'm sure it's been looked at multiple times, but in reading and rereading it, I think the crux of what they are saying, and I'll give you exactly. It's over on the last page. When read together, and this is read together, both the USPAP compliant and then an evaluation, a non-USPAP compliant, when read together, these two sections clarify when the USPAP and other appraisal standards are applicable to work performed by an appraiser. These standards apply to all appraisals except for Section 104D evaluations. So in essence, and then over on earlier, he clarifies an appraisal, you have an appraisal, you have an evaluation. The only difference between those two is the circumstance in which those are performed. And the circumstance is those that are below the threshold that require that they can get an evaluation. So from an appraiser standpoint, they can perform them per this, and in nowhere does this state, the only requirement that it does state is to state that this is not an appraisal. It does not state you can't show your certification. And actually, he refers to them as an appraiser. My argument to that is, why should appraisers put on a fake mustache and sunglasses to perform an evaluation when that's the makeup of who they are and how they became an expert valuer? It's just promoting misleading right from the get-go if you don't state who you are. The credentials is what makes them able to do that. Unfortunately, they're not held to USPAP. They're not held to the state commission. That's not our fault. That's the circumstance in which they are, because the Appraisal Standards Board hasn't included evaluations as part of USPAP. But Tennessee has probably the best law on the books for appraisers to perform evaluations. We are charged as a commission to protect the public. So does it protect the public to tell an appraiser that they can't state that they're an appraiser? Does it protect the public if banks can't use appraisers, but they have to go outside the area and let someone in Utah perform an evaluation when they've never set foot in the state of Tennessee? That doesn't protect the public. And I think the Q&As set forth allow appraisers, it's clarified what appraisers can do, and I don't see the point. If you're communicating that this is not an appraisal. You can jump over, and we have the same thing on the USPAP side. You have a restricted appraisal report, and you have an appraisal report. Well, there's many that say a restricted appraisal report is confusing to the reader. It is, but it's clarified.
You still have to comply with USPAP.
You have to comply with USPAP.
And that's where, and I don't want you to misunderstand what I'm saying. I'm not trying to say that I don't think appraisers are qualified or even the most qualified person to do evaluations, because that's not what I'm saying at all. I guess my question is if, and I may be saying this incorrectly, and I'm sure you'll correct me if I do say it wrong, but is there provision for a jurisdictional exception that the Attorney General could specifically state in here that would be acceptable for an appraiser to add their credential on an evaluation? If you're saying what you're saying, he's pretty much almost already done that, except we haven't gotten it. So if an evaluation comes in, and although it says this is not an appraisal, because when I took a class by one of the commissioners in here, he told me if I got a phone call from my buddy and he asked me what the value of a property was, and I told him that it was $230,000, I was acting as an appraiser, and I just completed an appraisal.
That's sort of different than what this is. This is set forth, these evaluations are done specifically, and the Attorney General specifies what those are. And that's the requirement set forth, that they're not FTRs. And basically, things under a threshold, if they meet the requirements that an evaluation can be performed, an appraiser can do them.
I'm not disputing that. I'm trying to prevent the fact that, how do we make the determination when this comes in that there's a value on there, even though it says it's not an appraisal, and the appraiser signed it, and he's put a certification on there? I think there's an argument to say that he should have complied with USPAP. He or she should have complied with USPAP.
I think technically, so I think I've gotten maybe one evaluation in the almost 2.5 years that I've been here. But if I get one in and it is determined that it meets 1040 everything, I would come to the commission and say, this is an evaluation, it's outside of your jurisdiction. The only issue that I would have, and I think I see your point on this, is that once that appraiser has placed his appraisal license number on there, as if I were putting my bar license, that person is holding themselves out as an appraiser. So do I then have to look at it from, even though this is outside the jurisdiction of this commission, do they have to meet certain USPAP requirements because they're now holding themselves out as an appraiser, which we are, granted the authority to look out for the public and go and make sure that appraiser is meeting all the requirements necessary.
And there's only one, the only place this even applies is in banking. And the bank's required to know the qualifications of the evaluator. But the reality is, if this is in an owner-occupied transaction, no, it doesn't matter if it's an appraisal or an evaluation, the consumer still gets a copy of it. They're required to by law. So this isn't just sitting in somebody's desk, going in a file. The consumer still is required to get a copy of this. So you're giving a copy of this to, I'm not going to say an uneducated consumer, but an uninformed consumer who doesn't agree with the value. Sometimes they're real estate agents. And I feel like this can turn into a bigger issue.
I'd like to make a comment. A couple of them, in fact. There are two issues, USPAP issues, that I perceive from this. The first one is the moment that an individual represents himself as an appraiser, then he is one, and he does have to keep USPAP. So if he does not represent himself as an appraiser, he does not have to keep USPAP. And so if I'm saying this is not an appraisal, then I should not represent in any other way that I am an appraiser.
So what you're stating is they probably shouldn't include their appraiser license.
I don't
number
think
on
that's
that.
right.
And secondly, USPAP only requires a certification for two things, an appraisal and appraisal review. There's no certification requirement for anything else in USPAP. Now, there may be state law that I'm not privileged to. The state may have laws opposed to that, but that's it.
Yeah, I don't think that's right. The certification, if you belong to a professional organization, if it's a non-USPAP, you have to.
If you're representing yourself as an appraiser, as a member of a professional organization, then you're going to have to use a certification. But you're now an appraiser, you're not an evaluator.
No. I totally disagree. And the unfortunate side is this stuff was presented in November and then in January for this to be hashed out. And those questions were put out there for this discussion to occur, and none was taken.
And I
Well,
wasn't
I
here
would-
for one of those meetings.
I would go to
apologize.
say that just because they weren't discussed then doesn't mean they shouldn't be discussed now. I think this is an important topic, and that if we do have,
Is anyone opposed to having the Attorney General just look at that? And if the Attorney General states that,
So
then
number-
we have a jurisdictional exception. and
number
then
one,
it's-
asking for an opinion is a little more complicated, and just if we could get a different answer. I mean, that's something that you all need to decide if you want this opinion. It's could be a different individual reviewing it. So that's.
Say a different answer. What do you mean by that?
I mean, they could look at number one on this and say yes.
Okay.
So that's completely up to the board's will.
Hey, hang on just a second. Mr. Button, you had your hand up. You have something to add to this, sir?
I just saw 2 points, and I'll say my name.
There you go.
Randy Button, and one thing on the jurisdictional exception, the Attorney General's opinion would not allow still for a stipulated jurisdictional exception. That would have to be something that would be statutorily in place that would be in contradiction with USPAP. So if there are provisions that were in state law, so the Attorney General, all the Attorney General can do is give you an opinion of the way they interpret the law. I'm not an attorney, but that's the way I understand it legislatively. On the second issue, if you will allow me, Mr. Chairman, just kind of go back in history just a little bit.
Sure, go ahead.
I was part of the original legislation when we put the laws in place. We passed the legislation, the first legislation, and was...
Is that the 2010?
No, sir. This goes back to 1989.
Oh.
Okay. I was actually helped draft the legislation to get that passed in the legislature that put together everything that we're operating from when this went into place. And if you'll allow me, I'll tell you the history. The history was that this provision was brought to us by the Tennessee Bankers Association. We put this in place, and we were the only state that did this when we passed the original legislation. Other 49 states had to pass this as well, and jurisdictions. We put this in place, the evaluation, to allow one thing, to allow who the most qualified folks to do evaluations would not be exempted or be boxed out because of USPAP as an appraiser. They were the most qualified. The bankers, the financial institutions saw this coming. They said, we have people now that are qualified who are appraisers, that we want them to be able to provide this product. Then the de minimis level was a lot lower. I think at that time it was only $100,000. Okay, it got increased to $250 and now to $500. So this product that, and I think this is what Commissioner Garrison is saying, as also this product, that it was intended that for this evaluation products, that appraisers were the best qualified. Why would we box them out and eliminate them just because they had to adhere to USPAP? Now, going forward, now we're in a position where other states, I think there's 6 other states now, that have passed similar types of legislation we have, and a lot of other states are considering it. With the Standards Board not addressing this as maybe a third type of report, which would alleviate some of these problems, but we don't have that. So now we have to give some kind of direction and guidance to our licensees in our state on what they can do or what they can't do and how they do that. And I think what Commissioner Garrison is saying in this is this was never intended to try to fool the public and saying by not putting your license or certification in there, this is just another product that these folks can provide, but it doesn't have to adhere to USPAP. I think the way I read the Attorney General's opinion is similar to what Commissioner Garrison is saying, is that this is a carve-out in our law that allows these people to do this, that allows our licensees to do it. We shouldn't try to put additional layers of constraints on what they can or can't do because they're already qualified and able to do this as a licensed certified appraiser. So simply putting your title, I don't think makes it something that it's not that's already allowed for, if that makes sense.
Right. Well, the chapter says that there's nothing to prevent a state licensed appraiser from doing it.
That's why we put that in there,
Yeah.
because we didn't want to hamstring our licensed certified folks who were the most qualified to do it. Now, there is one other caveat to this, and that is that many appraisers belong to professional organizations that have their own standards of practice that they have to adhere to. Those standards of practice sometimes require you, under any product that you provide, whether it's an appraisal or an evaluation or any consulting assignment or anything else, that there's certain things you have to do to adhere to their standards. Again, this is a situation where appraisers are members of those organizations may be required to put a certification in there to adhere to those standards, even though it's not an appraisal. They may have to also put their professional designations and require those. And there's other ethics requirements they have to follow. Regardless if they're doing appraisal or not doing appraisal, they still have to follow those standards and ethics that are set out by those organizations, whether that's the American Society of Appraisers, whether that's NAIFA, whether that's the Appraisal Institute, whether that's the Realtors. So those are also standards that have to be provided. So again, by us saying you do this or do not do this, again, that's putting appraisers in kind of a box, and I think they should be allowed to have the flexibility to do whatever needs to be done in a product that this commission does not really have jurisdiction over.
I see both sides of the argument.
Okay.
Legally, I could go make an argument on either one. I could say, you put your number on there, you're holding yourself out as an appraiser. I can go at you on that. I see the other side saying, I'm just simply letting the people know that I hold this license. I think it could go either way. I think that since we're limited on time today, I do think this is going to be a bigger discussion because I think that we have differing opinions. I would like for you all to think about if you want the AG's opinion. It's a lot. We have to come up with the questions. It has to technically be presented like this, where here are the questions that we have for you. These are not an overnight thing. This could take a year. It could take 2 years. But I think that's something that we need to think about.
I have a question of clarification to Commissioner Garrison. Are you suggesting that an appraiser has to put a certification in there, or he has an option and he could
As
leave
an
it out?
option,
As an option?
yeah.
I got no problem with that.
Let me ask you something, Sarah. Just where it says on our agenda, evaluation, question, discussion, do we hope to accomplish a specific something?
This question just came to Roxanna and I, and we wanted to bring it to the full attention
Okay.
of the board because we're not the experts to answer that question. That's for you all to look at and say yes or no. I am going to go back and pull the evaluation question and answers and read through them again. I do think we need to make sure that it does say this is your option to put your license number. I mean, I feel like I'm kind of.
I don't think there's
like I'm
anything,
caught
any
between a rock and a
requirement
hard place.
language
No.
in there.
Yeah, I'm gonna have
But-
to go back through and pull it and look at it with my.
But
chief
either
counsel
way-
because
Either way, it shouldn't matter. I mean,
well, I mean, with the differing opinion on the board, I'm gonna have to go back and discuss with my superiors if having the FAQ up there saying one way or the other is where we should be. So it may be that question comes off altogether, just because.
I think appraisers need to know what they're able to do, and I think the board should be giving them guidance on that. So I'm just, this is nothing more than concern that this is going to turn into an issue for, if not us, another board down the road.
well, here's the thing. In smaller markets, and I'm just going to throw out an example. If I do an evaluation and I don't put anything on it, they know who I am and what I do. So I'm guilty for who I am. And my thoughts on all that is, and as Mr. Button indicated, appraisers have been put in a box, and not almost made to feel like we can't do those because we are an appraiser, and I don't see where being it is all it is a product. It is a non-USPAP product. Is all it is.
Well, you're not an appraiser when you're completing that product. You're not acting as an appraiser when you're completing that product. Because if you were acting as an appraiser when you were completing that product, you would have to comply with USPAP. So it's not either or. You can't have it both ways. It's got to be either I'm taking this hat off and I'm putting this hat on, or you're not. I think that's pretty clear.
I think it's a kind of a technicality there. It is probably a clear technicality, but again, I'll go back to where the chapter says because you're licensed or certified doesn't say you can't do this. But this appears to me to be more so than the other topic. We might need to put a group together to say, hey, let's propose these questions. And I know the wheels of justice turn slow, but I didn't realize they were completely stopped. I just can't imagine that it's going to take a year to get something back from the Attorney General to say, yeah, this is it, or no, it's not. I mean,
Well, you're also looking at possible change in administration.
And keep in mind that you have an Attorney General's
We have an opinion
so-
already.
So the concern with that is that it's going to take longer because
They're going to go back.
They've
and
gotta
look
go
at
back to
this
that.
And look at the research on this matter. We have to decide if we're proposing the exact same questions, if we're
Sure.
going to propose different
Sure.
questions.
Well, in Mr. Button's point to that certain associations may require you to put your certification in there, those same associations had appraisers in the box you're referring to because they did not allow the
That box
people.
no longer exists.
It no longer exists, but it did up until fairly recently.
And I think one thing we need to recognize is in this profession, we are in changing times.
Very much.
And we need to adapt to, we can't constrain this profession from acting as a profession. And we've got to make some adjustments. I thought we had this cleared up.
And that-
The only thing in question for me is putting certification on there or not. There's no question to me at all that an appraiser is very qualified, more so
Or
than most others.
certification or your license number, what?
Either or. I think that if you're doing that and you're telling people that you're acting as an appraiser, that
You're not necessarily acting. You're stating that this is not an appraisal, and that's what this states. That's the only requirement.
You're coming up with an opinion of value, and you're putting your
he even
certification.
He even says,
All right, gentlemen, for the sake of time, let's.
Can I just,
Hang
before you...
on just a second. Hang on just a second, Rex. Okay, Mr. Atwood, go ahead real quickly.
My only point here is that the moment you do an evaluation, this board has no jurisdiction. Is that correct? Whether you're acting as an appraiser or you're not.
We have no jurisdiction over the evaluation. We have jurisdiction over the appraiser.
Over the appraisers who are doing evaluations.
I mean, our authority is over the appraiser. So if they have a
they're
license
acting as
with
an
us,
appraiser?
my opinion right now is if they come in with an evaluation and it meets the qualifications of an evaluation, it is outside the scope of this commission. That is what my recommendation would be, that you have no authority over this. Now, if we have some type of argument that, when I'm in non-legal situations, I don't hold myself out as an attorney because I don't want somebody to file a bar complaint on me for no reason.
If a complaint was submitted to you on an evaluation performed by an appraiser, licensed appraiser, but it was on an evaluation.
My recommendation to you all would be this met all of the qualifications under 104D as an evaluation, and therefore you have no jurisdiction. That is my interpretation as of right now.
If there were violations.
Well, I mean, that would be USPAP violations.
USPAP's is not required of an evaluation.
But here's what we are seeing, and I don't know if it's okay for me to say this or not. We're doing some compliance reviews on evaluations that are very much bleeding the line back and forth. There's some commentary in there that shouldn't be in there. There's some things that aren't necessarily completely complying with the requirements of an evaluation, and it happens way more than you would imagine. And this is where this concern is coming from. It's on a compliance review because these are still required by the FDIC, the OCC, the Federal Reserve to be reviewed. So when we're getting these in and we're looking at these and we're going back and then it's getting kicked back to us saying, I'm fine, I don't have to worry about it, we're turning the assignments down for compliance reviews because of the line bleeding back and forth.
well, the thing I would point out on there is, as far as commentary, what commentary would it be? I mean, you're having evaluations performed by non-appraisers.
They're not putting USPAP information in. A non-appraiser is not putting USPAP information in on an evaluation.
Like what, for example?
I couldn't give you an example off the top of my head, but I can send you some to show you exactly what I'm talking about.
All right. We're going to halt the discussion on the evaluations for right now. I appreciate everybody's intensity on this, and apparently it needs further discussion. And I'm not so sure that if it's going to take so long to get that we might need to apply to the Attorney General now to see what he has to say.
Let me run that by them upstairs
Sure,
just
no
to
problem.
get their opinion, see what
Sure.
they say on doing it since we already have an opinion.
Okay.
What their
Okay.
thoughts are.
That's no.
We've run this through, the Q&As and whatnot was run through upstairs originally.
But at that point, I think we were all under the understanding that that the commission all agreed, and we didn't have still a debate going on. I think we have a debate going on, so
Yeah.
that changes things.
Yeah.
Because administration, just like us, is not going to know this is right or wrong. But if you all are still kind of split, or at least have some concerns, they looked at it from the legal, point and that
We looked
kind of
at,
thing.
everything lined up under what we stated from a legal standpoint. So I think that we would all have concerns if there's a divided.
And I don't have in front of me the question. Have we specifically laid out how they're supposed to complete it, or just to follow
The Q&As are, and it addresses your questions specifically. It addresses the certification, and it addresses putting license number on it. It addresses putting designations on it. It addresses everything that you mentioned. And that was thrown out at 2 meetings for this to be hammered out.
So Sarah, will you bring us back some kind of clarification?
Yeah,
And can you do that before our next meeting? Send us something?
yeah, I'll try to pull something together.
Okay.
I mean, I'll,
That's good enough. You said you will. That's good enough for me. Roxanne, you want to give us a budget report?
Thank you, yes. So on page 47 of your iPads is our budget. The last 2 months, we don't look great, but that's just because most of the cost backs are being charged. So I think we're still going to end, of course, with plenty of money back at the end of this fiscal year. We should have closing numbers, well, definitely by the October meeting.
How are we doing as far as
The reductions?
well, yeah, when I had to appear in front of the Senate?
Yes, so we have the rules in the pipelines working through to reduce some of our fees and get us to a better place and not have so much
no,
overage.
you know we like that word. I
Okay,
can tell
but-
you
Pipeline.
the fee.
But I mean, as far as the rules being in the pipeline.
So I can tell you where they are.
Okay, please.
They just went to the governor's office last week. The governor's attorney has reviewed them, sent them back to me. Today they will be sent to the attorney general's office for final review. Once we get that final review signed version back, then they will be filed with Secretary of State. So we're probably at 90 to 120 days right now.
And that's going to the Secretary of State.
Yeah, it has to be filed with Secretary of State and sit on the record
Okay.
for 90 days for
Okay.
comment.
Okay, good deal.
That's good.
All right.
Next, we have just a quick update on the waiver request that I think you all are aware of, which is on your iPads. Basically, this is regarding the TriStar request to the ASC. The last that we have been informed officially that it was denied and they posted it. Now, I have reached out to Jim Parks because there was a thought that they were going to meet and present something else, something different. That's not been responded to me. So to the best of my knowledge, there's nothing else. It kind of ends there. But if you hear anything else or are concerns, remember, all we need is a public records request. I can make all the data available. I mean, it's at our fingertips. I just can't provide something I don't know who needs it or what they need. So that's definitely an option.
Okay.
The National Registry, what I wanted to update everyone is it opened as of July 16th for us to be able to enter all AMCs.
It's today.
Today. My hopes was to get right on it and start entering it. So 2 of the pieces of data that it asks for are mandatory. Not seeing the actual layout of what it would look like and what would be mandatory and what would not, I thought we would have it all. One of the questions is the number of appraisers on each of the AMC's panel, and we have not been asking that information because we didn't need it. I wasn't concerned about the technology being developed because we won't be necessarily paying into it until June 4th of 2020. But the data is required, so I can't start entering until we have the data. So there is a very good WebEx, if you will, they've put together. It's on the ASC's website. I am going to email it to all of you, especially AMC companies, or if you get questions from other AMCs, because they'll want to maybe see it. It kind of addresses what the states will have to do, how the audit will work, the $25 per person on the panel, and all that information. I think for now we're going to reach out and just make sure to let Jenny or whoever know that we're not going to enter the data, because right now we don't have that magical number. So what I would like to do is in the next 2 months to 6 months, send out a letter to all of our registered AMCs, let them know that we're going to start entering the data in the registry, and give them some information. I just don't want them to get a renewal or be a new appraiser management company coming in and have these questions that they've not been prepared for.
When you stated your timeline there, you mentioned previously, or Sarah mentioned previously, that we would be visited in January. With us not presenting those, will that be a ding against us?
We don't have to enter anything mandatorily until 2020.
Oh, okay,
So-
very, very good, very good.
We had hoped to do it sooner, just because
Sure.
we've changed our rules, we're
Sure.
in compliance with everything else. Just that piece, and then making a decision whether we are going to do single years or multiple year.
Okay.
And of course, we renew every 2 years, so that's in debate, and I really didn't think that those 2 pieces had to be decided this early.
Okay.
So we're going to start on the technology. As you all know, we do everything online through core.tn.gov. So I need then that technology to be out there and ask the question and have a place to feed it, since it's mandatory. So we'll get. And then the last item that I've got under new business is I'm going to hand out to everyone your 2019 commission meeting dates so that you can take them with you and we can vote. For the record, we've got January 14th of 2019, and that is when the ASC audit they will be here to meet with us, but they will actually then stay and do the audit after the meeting. They will not be presenting audit findings. They've changed the way they do business. So, but they'll be meeting us before they start and be here for our meeting on the 14th. April 15th is the following meeting, July 15th, and October 21st. So you can take these with you.
Anybody else have any new business?
The only other thing before we wrap up,
Thank you, ma'am.
Roxanne and I have gotten a few emails lately, and we would just ask that if anyone is contacted by outside individual, if they have questions on how the board does business, questions involving law, just send them our way. We don't want to put one of you all in a situation where you're answering questions on behalf of the commission without the commission's authority. So
Sure.
just send them to Roxanne and myself.
Sure. Anyone else?
Just a point of beginning to think, not to necessarily discuss it today. The interview process that we went through today, and some of you have more experience with it than I do, we don't really have any guidelines for that. And just as we didn't have any guidelines for a scope of work for reviewers, we don't have any guidelines for how to conduct an interview and what is expected of us, and what if we decide not to approve somebody at some point? What are our options? As a new commissioner, I don't know what those are. So if there's something in writing, great, get it to us. If not, we probably need to start a discussion on getting that straightened out.
Piggybacking on what Mr. Atwood just said, was my comment about the selection of examples of their work. We need at least one to be selected relatively recently. Like I said, the first gentleman I interviewed, all of his were 15, 16s, and I said, we've been doing since 16. He said, well, I've been working, but we didn't have anything updated that shows what he's currently capable of doing. So I'd like to make sure that, I don't know who does that selection.
And that's, we've just changed staff. It was not going
Sure.
great, is about all I can say. So
Okay.
that won't be the case.
Okay, good.
We'll definitely have somebody review the reports, pick logical reports so that they make sense in our
Recent,
current.
yeah.
Well, I will say, though, when the letter is sent to them originally with the chosen, we choose one in the beginning.
They can submit something different than what you
Well,
request?
I mean, it depends on if they didn't put the correct. I didn't choose all of them but one. Brad chose the. He told me.
But let me ask you the following. So that doesn't matter because we can change our process. Do you prefer the reports to always be current and not look at the older reports?
No, but we need at least one to
I
see.
agree.
I'd like to have one when they start
Okay.
in the middle so
And
that
that's
I
been the thought.
can see a progression of
Progression.
improvement, yeah.
Perfect.
Yeah.
Yeah. No, we'll get there. That makes sense.
Rex?
One other question I'd like to throw out, because this was thrown out to me and I really don't know the answer. Now that the threshold has been increased to 500,000, can a certified residential appraiser do non-complex commercial properties up to 500,000? And that's beyond our scope. But that was posed to me, and right now it's still 250, and it was set 250 when the level was set, the threshold was set back then. But that's going to require something from the standards board, but
Question together and send it out to them because we haven't seen it either. Okay.
Anyone else? Make a motion to adjourn?
so moved.
Second. Motion been made and second. All those in favor, leave. Thank you very much.
The
wanted to thank you for your reaching out to that.
That's what I was
The
thinking.
AQB would have
Unless
to
it's
make a
a,
change.
unless it's a
Yeah.
eval.
They don't, and it's no jurisdiction.
I know.
You do whatever you want, Randy.
But here's another thing. Don't get hung up on this opinion of
On the
value.
record that we appreciate